Hi, I am Chiraiya Saruparia and today we will learn about sources of Hindu law. Sources. This term generally means the origin of something. That is, from where does a particular thing or a concept has been originated or from where does it came. Sources of Hindu law therefore means from where does the Hindu law originated. We all know that Hindu law can be compared to one of the oldest system of law that is known to the world, and therefore it is very difficult to track and trace the original sources of Hindu law, since we have to go back to an era where there were no written communications. Religion, law, and morality, these all words had similar meanings and were commonly referred to as dharma earlier. What are the sources of Hindu law today were earlier the sources of Dharma. Moving further, sources of Hindu law have been divided into two categories, the ancient sources and the modern sources. We will start with the ancient sources, which are further divided into five types: Shruti, Smriti, digest and commentaries, custom, and king edicts. Shruti has been evolved from the term Shru, which means to hear, and therefore Shruti means what has been heard. Has been heard by whom? By the great sages during their state of trance or anything which was revealed to them during that state. And therefore Hindu law has many times referred to as revealed law, since it contains the ipsisma verba, that is, the precise words of divine revelation. In order to add a touch of authenticity and authority, this element of divinity has been attached to Shruti by its original interpreters. It is also believed to be the ultimate source of law, since it governs the human conduct and contains the roots of Dharma. This divine utterance, which came down through the seers and sages, is found in the following: first, 18 Upanishads; second, 4 Vedas. It is very important here to know the 4 Vedas. The first is Rig Veda, which is rich in mantras and includes the praise of forces of nature. The second is Yajur Veda, which includes the rituals. The third is Samveda, which includes the prayers, and the fourth, Atharva Veda, was added much later and includes magic spells and incantations. Third is the 6 Vedangas, that is the appendages to Vedas. They are: first, Kalpa, that means art; Vyakran, which means grammar; Chanda, which means couplet; Shiksha, which means education; Jyotish, which means astronomy; and Nirukta, which means reason. Moving to the second ancient source of Hindu law, that is Smriti. It has been evolved from the term Smro, which means to remember, and therefore Smriti means what has been remembered. It is the recollection of human mind. It can be understood as the pursuit of great sages and rishis who had some revelation present to their memory and then recorded them and then handed out these recordings generation to generation. These are the blends of various religious, moral, social, and legal duties and obligations, and contains rules regarding marriage, succession, duties of king, rules of partition, stridhan, etc. The Smritis can be divided into two categories. The first is early Smritis, also known as Dharma Sutras, and second, later Smritis, also known as Dharma Shastras. It is important to know here that Smriti always comes next in priority to the Vedas. Rishi Vyas observed, where there is a conflict between the Vedas and the Smritis, the Vedas should prevail. Coming to the first category, that is the early Smritis, Dharma Sutras. They were mostly written in the form of a prose. There were few which were the mix of prose and verses, but most of them were in prose form. They incorporate the teaching of Vedas with local customs, and therefore they were considered as training manuals of sages for teaching the students. They explain the duties of men in various relationships, and they mostly provide the rules of guidance for different stages of life. But they are not the exclusive codes on civil law. They only explain the rights and duties of the Hindus. The chief Sutrakaras, whose Dharma Sutras are commonly known, are Gautam, Bodhyan, Apastambh, and Vashisht. Dharma Shastras, or the later Smritis, included the shlokas which were based on Dharma Sutras. However, they were a lot more systematic and clear. The subject matter of Dharma Shastras has been divided into three parts. First is Achar, which included the theories of religious observances. Second is Vyavhar, which included the civil law. And third is Prayashchit, which includes the expiation. We are going to study now the three most important Dharma Shastras. The first being Manusmriti. Manusmriti is the foremost in rank as well as authority and was compiled around 200 BC. It defined the way of life not only in India but also of Java, Bali, and Sumatra. Though the name of the real author of Manusmriti was not known, but it was observed that he was a Brahmin protagonist and was particularly harsh on women and Shudras. The second is Yajnavalkya Smriti. The language of this Smriti is very direct and clear and a lot more logical. It gives more importance to the customs and observes that king was only the enforcer of law and not the maker. The Smriti mostly dealt with the civil law and not with religion and morality. However, it differed from Manusmriti on some points, such as the position of women and Shudras, and therefore it is considered more liberal than Manusmriti. Mitakshara is the running commentary on this Smriti. The third is Narad Smriti. This Smriti is well preserved today and its complete text is also available. Like Yajnavalkya Smriti, it also gives much importance to the customs. It recognizes widows' remarriage and women's power to hold and inherit property. This Smriti is more logical than the earlier two and more precise. However, it differs due to the changes in social structure. Now we move to the third ancient source of Hindu law, that is the digest and commentaries. When Smritis did not agree to one common point, there arose a need of a modified text. So, commentaries were the modified original text along with the local customs and conditions. Tika and Bhashya are the form of commentaries which were mostly written after 200 AD. They also helped in setting up of different schools. Nibans, which are a form of digest, were mostly written between 700 AD to 1700 AD, and they incorporated and explained the material from all the Smritis. The basic objective of digest and commentaries was to gather the scattered material available in preceding text and present a unified view for the benefit of society. The most important digest is Jimut Vahana's Daya Bhaga. There are a few examples of commentaries here. Commentaries on Manusmriti, Yajnavalkya Smriti and Narad Smriti. Now we come to the fourth ancient source of Hindu law, that is the customs. From the earliest period, custom or achar is known as the highest dharma. It signifies a rule which has obtained the force of law from long usage in a particular family, class or society. It has also been codified along with usages under Section 3A of the Hindu Marriage Act and provides that customs and usages are any rule continuously and uniformly observed for a long time has obtained the force of law among Hindus in any local area, tribe, community, group or family. The essentials of a valid custom are also mentioned therein, and It provides the custom must follow antiquity and certainty. The custom must have been continued for a long period of time. It shall not be discontinued in between. The custom must be reasonable and not immoral or opposed to public policy. However, the codified Hindu law has abrogated the custom except in few matters where customs have been expressly saved. For example, the prohibition of marriage on ground of blood relations. The most important question which comes here is that how do we recognize an important question which comes here is that how do we recognize that it is a custom? The answer is provided in Indian Evidence Act under section 48, which provides that the opinion of a witness on the existence of a family or community custom is admissible in the court of law. Moving further to the fifth and the last ancient source of Hindu law, that is the King Edicts. There were various commentators like Medadathi who expressly commented and stated that a king could not make any rule which is opposed to the Shastras or usages of the country. The king was always the one who executed the law and never formulated them, except in a situation when king was the adjudicator. These were the ancient sources of Hindu law. Now we move on to the modern sources, which are three in number. The first is equity, justice, and good conscience. The second is legislations, and the third is precedent. Equity, justice, and good conscience. Equity generally means fairness in dealing. That is, for example, if there is a person A and a person B, to deal with them fairly would be to bring them to a similar positions in society. Delivering true justice can only be done with equity and good conscience. There may arise a situation when no rule is given, and in those situations, the sense of reasonableness must prevail. Yajnavalkya observed that wherever there are conflicting rules, the decision must be based on nyaya, that is justice. The decision must be just. The second and very important modern source of Hindu law is legislation. No one can deny the importance of legislation in our country. It has become a potential source of law in the post-independence era. The parliament constitutes new laws, amends and modifies the earlier laws based on the needs and requirements of the society. The Hindu law has also been modified, altered, and supplemented with various legislations and has been codified now. The examples of legislations of Hindu law have been given here. The last and the third modern source of Hindu law is the precedents and the judicial decisions. Article 141 of the Indian Constitution observed that law declared by Supreme Court shall be binding on all the courts. Dudnath versus Satyanarayan, it was a case in which it was observed that Hindu law is not the Shastric law enunciated in books, but it was a law which was interpreted by the courts in India. And therefore the doctrine of stare decisis is applicable in India. It means that we will stand and abide by what has been earlier decided. And therefore the cases are now recorded and decided on the basis of existing case laws along with the legislation. These were the modern sources of Hindu law. To have a quick recap of what we have learned till now, I have made us a flowchart. Sources of Hindu law have been divided into two, ancient sources and modern sources. Ancient sources are further divided into 5 types: Shruti, Smriti, digest and commentaries, customs, king edicts. Shrutis have been divided into Upanishad, Vedas and Vedangas. Smritis have been divided into early Smritis, Dharmasutras, and later Smritis, Dharmashastras, which have been further divided into following categories. Then, modern sources of Hindu law have been divided into 3. The first is equity, justice and good conscience. Second is the legislation, and the third is the precedents. we have completed the topic Sources of Hindu Law, and I would like to thank you for watching this video.